See you on the other side, guys.
Well, good afternoon, everyone, and welcome to today's webinar entitled Incident Reporting, a Property Manager's Survival Guide. My name is James Campbell, and I'm the Senior Manager of Industry Relations with NAA. I want to welcome all of our members in attendance. Thank you for joining us for this important topic. Before we get started, I want to go over a few housekeeping points. First, this presentation is being recorded and will be posted to our website and YouTube channel next week. You may then share this presentation with those colleagues and friends who are unable to attend at present. Second, we have a lot of time at the end of today's presentation for live questions and answers, but you may also type your questions into the Q&A or chat boxes on your screen at any time during our presentation, and we will share them with our presenters as soon as we are able. Third, a brief disclaimer that the information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information provided is for general informational purposes only. Moreover, all situations discussed within the case studies to follow are for discussion purposes only. Facts and circumstances have been altered to preserve client anonymity. Now, I am very pleased to introduce you to today's host, Wendy Dorchester. Wendy is Senior Vice President of Operations and Culture at Pegasus Residential, where she is crafting and executing strategy to streamline operations and create a winning culture. Wendy brings nearly 30 years of experience across all facets of rental housing, with prior senior level positions at RentPath LLC and Brown Investment Properties. She holds a BS from the University of Maine and serves as chair of NAA's Operation Committee, among other industry leadership roles. Wendy?
Well, good afternoon, and thank you so much, James. And I just want to say thank you to the audience for joining us. And, you know, in many areas of the country right now, or I should say in the Southeast, we're faced with a hurricane that's upon us, Hurricane Ian, and this incident reporting webinar could not be more timely. So I just want to mention that I know that my teams are taking videotapes of all their properties and what their conditions look like prior to the storm. And that's a best. In my line of work, I review incident reports every single day that come across my desk. And I felt like this was a worthwhile webinar to give the general, membership of NAA incident report writing, in support writing. So both of them at their law firms. Thomas Howard is partner at Brownlee, Whitlow and Prate. He practices in the area of residential and commercial landlord-tenant law, residential and commercial real estate litigation, commercial collections, community association law, and contract drafting. He joined the firm in 2015 and became a partner in 2020. And he also serves on the Legislative Committee and Education Committee of the Charleston Apartment Association in Charleston, South Carolina. Thomas holds a JD from the Charleston School of Law and a BA from Clemson University. Thomas, I want to thank you so much for joining us. He's a partner at Taylor English Duma. He represents individuals and companies in litigation litigation matters, including business, contractual, real estate, and resort and hospitality disputes. Also has extensive experience representing those who are subject of complaints and claims under various consumer protection statutes and agency investigation. He served as president of the North Fulton Bar Association, among other interests. Matt holds a JD from Emory University and a BA from the University of Michigan. I want to welcome both gentlemen to the stage. And Thomas, perhaps we can start with you and your thoughts on incident reporting.
Thank you for that great introduction, Wendy. And thank everyone for allowing me the opportunity to be here. And I really appreciate the opportunity. And also, it's always a pleasure working with Wendy, Matt, and Jim. So today we're going to talk about successful reporting, incident reporting, gathering that information. How do we do that? Why do we do it? We're going to go through just some basics. My presentation is very brief. It gives you kind of the overview, very bullet pointed kind of idea of what you're looking at. And then we're going to go to Matt, who's going to take it from there and give you some real life examples where we changed the names, like we said, to protect the innocent, right? And so we want to make sure that you get a lot out of this. And so we want to show you the why this is important, why this is necessary. And so we're going to start with the 4 W's. So that's my key takeaway for you today is the 4 W's. So ask these questions. When an incident happens, where did it happen? When did it happen? What happened and who was there? And why are those important? Is the 5th W, even though it's just not on there, it's 4 W's. So I want you to remember those when you're writing that incident report. So the where is, was the incident on site in the residence or common area? That makes a difference. You need to know these details as you go through your reporting. When did it happen? Was it day? Was it night? What were the conditions of at the time of day? So from there, you go to the time of day is important, especially slip and fall, trip and fall, other issues along those lines. The where it happened, it also what were the surroundings. So we get into the what. So what is the meat of your report? So what happened? What's going on? What from what you can gather, what information can you gather from witnesses, and then the who was working and on call, who were the witnesses to that incident, as much information as you can. So you're going to go for the 4 W's. That's going to run through this entire presentation. It's where, when, what, and who. If I can do the next slide, please. So creating in-house incident reports. So again, referencing the 4 W's, that is the most important aspect that gets you the bare bones, gets you going. You start asking questions. Think about Murder, She Wrote, right? Jessica Fletcher, was this the, for those of you who are fans, my wife's a big fan. So she, she inserted herself in investigations, right? Not realistic, but she asked those questions. She got those details and she got that information. So you can kind of think of yourself as a little bit of a detective when you're handling these incident reports. The importance is training your on-site employees. So that kind of goes without saying, right? You as your on-site team needs to know just as much as your regional, just as much as your VP. What's your process? What's your procedure? What does that look like when I put it on paper? Do I have a form? Do I need to create a form? Do I need to get videos? Any kind of mediums or information that you can gather. That includes witness statements. What happens? Even if it's something as mild, you can have a dog bite, thinking like things of that nature. Or mold or organic growth situations. Is gathering those witness statements, figuring out what happened. I have some slip and fall cases that are going on right now, or trip and fall. So we need to know who was there, who saw it, what were the conditions, and then also you're looking at external documentation. Whether that's somewhat be familiar with your insurance policies. What other documents are available to you? Were the police involved? Was there if it was a fire, to get fire marshal's report, anything of that nature? I mean, you're going to get maybe animal control involved. I'm trying to think of any other examples as far as you can go. External documentation is just as important as internal documentation. You want to make sure when the incident happens, you get that real-time experience of what was going on, kind of get as much of an overview as you can. Next slide, please. So for documentation background reporting, why is it important? So from me to you, the why, you need to know who was present. And that includes your employees who were on call, who responded to the scene, were other residents involved. So you can gather that information, submit it to your your insurance carrier if necessary, or your internal risk management, or your higher ups, your VPs, anybody who is there on site, your direct reports. The reasoning for that is that most lawsuits don't really occur within the few days after the incident, right? So there's a time period where they gather all the information, determine what the injuries are, and then you get a lawsuit. And in South Carolina, for instance, personal injury suits are 3-year statute of limitations, which means that you have 3 years from the date of that incident to bring the lawsuit. And a lot of times it happens on that last day. So 3 years from there. So I'm sure some of you can relate. There's been a lot of turnover. I'm sure, unfortunately, COVID's made it, there's lots of ins and outs, people changing jobs.
Yeah.
So,
And Thomas, that's such a good point, because I know just recently I've been involved in a lawsuit, and it happened, almost 3 years ago, and none of the on-site team are still there. So, and we sold the property. That's the other thing, the property sold. So in going through this whole process with legal, we had to go back into the payroll records to see who was on site at the time. And so one of the recommendations that I've made is on our incident reports to put who was on payroll the day of the incident report, so that if we ever have to go back to it, we know exactly who was, on payroll there. So you're making some excellent points.
And Thomas, I don't want to interject too much, but just for the benefit, because I know we have folks from all over the country, make sure to check your own particular state statute of limitations, because in Thomas's jurisdiction, it could be one specific time frame, whereas for me in Georgia, it could be 2 years, and it also depends on the type of claim. So always consult your legal counsel.
Exactly. Yes. Thank you for that, Matt. That is exactly correct. And to Wendy's point is to the employee turnover. Why you write that down is so you can go back and find that employee and figure out who was there. And then also, when you're writing these incident reports, that's your present sense impression. It's fresh in your mind. You don't want to wait 3-4 days to write it down. You document it immediately. And what that does is it creates a record, right? So you can go back and look at that. And so when we're in court, or when we get through the discovery process, as Matt and I know, when you're in the lawsuit, you can look back to that. You have your versions of the facts and what happened, and the plaintiff has their versions of the facts and what happened. So you're detailed, the more details, the better. You're not opining as to, why you think it happened. You're saying, here's what we have. Here are the details that we have at this particular moment in time. So the next slide, please. So the key takeaways, which we're going to take these and apply, and I'm just summing it up for Matt, because he's got some great examples for us to take and apply this information, all this record keeping and reporting to, is remember the 4 W's. If you can't remember other things from today, I know this was recorded, so you can kind of go back at any time. Just remember the 4 W's. That's your starting point. Ask those questions. So who, what, where, and when, and then that'll lead you to the why. So.
Hello, everybody. As Wendy introduced, my name is Matthew Rosenkopf. I'm an attorney in Atlanta, Georgia. I practice in both Florida and in Georgia. But what we're now going to segue in is some real life application of those 4 W's and why it's important. So the first step is obviously you have to understand every company is going to be different. Everybody has their own policies, procedures, and that could also vary from property to property. One property might have surveillance system. Another property may have a guard gate. So what you need to obviously make sure is that your staff is understanding of what they have at their disposal and that it is actually being used. And so we have created 3 different case studies just to give you a flavor of how those 4 W's can be applied, what the results could look like, where the dangers are, and where the intersection of all of that could be. And I also will invite Thomas and Wendy if they want to chime in from time to time if they'd like to. So I'm going to first give a little bit of disclaimer. As we said before, all these case studies are not intended to be real life examples from any one particular case. Give the old movie disclaimer that you see is any resemblance is purely hypothetical, and so on and so forth. So enough of the lawyer disclaimer. Also, this first case study, I want to give a small little disclaimer that it could involve some sensitive materials. If this is something that is personal to you, I suggest if you want to, mute me, that's fine. We take no offense. But the first situation we're going to talk about is involving violence against residents at night. So we can start with the background. So let me just give you a couple background facts, and this isn't obviously everything. Management receives reports of burglary, armed robbery, auto theft, forced entry, and indecent exposure on the property. So property management at some point in time has received somebody complaining about an incident. Okay. Fast forward in the future, a resident was leaving the gym. It was dark, but the way that this hypothetical property is lit, you could see into the gym, but you can't see out because of the way that the lighting is. Person's exercising, treadmill, weights, what have you, unaware that anyone's watching. How often do we go and exercise, for those of us that have time to exercise, and you put your AirPods in and you tune everybody else out, or you're watching TV? Well, in this particular hypothetical, after leaving the gym, the individual was assaulted at the fitness center. Fortunately, they were able to fight off the attacker. Everybody was able to, there was no longstanding injury in that respect, but the attack occurred. The individual then turns around, hires a lawyer, and files a lawsuit against the apartment complex. You can also see who else could be named here, but let's just, for this hypothetical, they just sued the owner of the apartment complex. And a jury turns around and returns almost a $4 million verdict. Now, each case different, allegations of going to psychologists, the trauma that's involved with being attacked, and so on and so forth. But we mentioned these facts to help spark questions in your mind of what could I have done and when? Because if you're waiting for after the incident to happen, and sometimes that could be too late. So let's go to the next slide, if you will, because I want to talk about some of our discussion points. Let's first talk about reporting obligations. That first bullet point is the most important. In a lot of states, and I can't say in all states, and depending on the incident, knowledge is going to be a required element. Just because something happens and you didn't know about it doesn't necessarily mean an owner or property management company is going to be liable. Again, every fact pattern is different. Every theory of liability is different. But once you are put on notice of an incident or of a problem, that triggers a heightened duty. So here they received reports, burglary, robberies, thefts, forced entries. This is a point where management should take those into account, do some further investigation. Where are those happening? Are they related? Are they all tied to one particular issue? Who is it that is reporting it? Don't take any reports lightly. I'm sure somebody's going to ask the question saying, we don't have time to investigate absolutely every single thing that somebody mentions. If somebody walks into your leasing office and says, I thought I saw somebody suspicious over here, encourage them to write out a written incident report and you'll investigate it. Because all you need is somebody to say, oh, I told them verbally, and you said I'd look into it, and it gets put in the so-called circular file, or you forget about it when the next person walks in the door. So encourage written reports and then follow through on those written reports. If there are lighting issues or someone's concerned about a light that is out, make sure it's followed up on. Security protocols, and we talked about this earlier. Every apartment complex, every residential community is different. But I'm sure we could all, not everybody has video cameras. Those are very expensive. Not all of them has private security that rides around on golf carts. But I'm sure we've all at one point or time gone to a property where that front guard gate is up. And then you go back a week later and it's still up. And you think, okay. And then you find out it's been up for about a year and nothing's really been done with that. Well, that becomes evidence in a case regarding security. Some apartment complexes have universal security codes to get in through the gate when you do have a call box. How are those codes distributed? How often does somebody know about it? I'm involved in a local softball league, and this obviously is not a property management issue, but we have a lockbox to our boardroom. And it's been the same code for about a year and a half now, that it's supposed to be for board members only, but I saw kids knowing the code to get into that lockbox. So what's the reason why I give that example? Once that universal code is given out, now you have no further control over who has it. And a wily plaintiff's lawyer will use that to your disadvantage if that happens to be how the person ended up breaching protocols.
That's
Then
a
you
great,
get, I'm sorry, go ahead, Wendy. I
No, I was gonna
apologize.
say, it's a great point, because I think we all have codes on our properties, and, different properties have different levels of sophistication as far as what they have on site. But, codes are something almost everybody has that they have to change around the property. And then also your comment about the lighting, I know at Pegasus, we do light audits that are due at a specific, date every month into our corporate office for every single property. So having a routine of having certain audits that you do all the time really shows that you're proactive when it comes to these measures. And so, Matt, you're giving some really great information for these folks on this webinar. Thank you.
My pleasure. So then the next 2 points are about preservation. These are, again, some of the W's that Thomas talked about. I, as a defense litigator in these kind of cases, the documentation is sometimes what will help a case turn one way or the other. If there are incident reports that are loosely filled out, that could really hurt, because now we no longer have a record of what was done, and you're relying on the memory of someone to say, oh yeah, we did this, 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 and this. Well, what is the other attorney going to say? Well, show me where in the document it says you did all that. Well, it doesn't. Do you normally record those kinds of things? It attacks the credibility of your employees or the property manager, or if you are one of the property managers on this call, it attacks your credibility on what you are doing. So record what you can record, preserve what you can preserve. Speaking of document preservation, and this is another very important fact to think about in the world we live in, most of you will probably communicate with employees over text. Email is easy. Email, you can easily record, run a search, find who you sent it to. But if you are shooting text messages to employees, it is not very easy to preserve text messaging. And all of that is discoverable, and all of that is another form of communication. Same point to the video recording preservation. For those communities that do have video on site, a lot of them have automatic deletion protocols, whereas if you don't preserve it or record it or save it somehow within a certain period of time, it is lost to the ether. And in a lot of these cases, once you are put on notice of a claim, you have to take action to preserve your documentation so that you don't get accused of what is called spoliation of evidence, which means you had what otherwise would have been favorable evidence, and but for you destroying it, it would have proved the smoking gun, so to speak, for the other side. So make sure you preserve everything that you possibly can. And then this last point, just also for discussion purposes, is who is liable and who can be liable. Certainly, the owner of the property in that hypothetical was sued, could be liable. Property management company, if they are put on notice of something and fail to take some action, they could be liable. In some jurisdictions, if an individual takes certain action, depending on what the fact pattern is, that individual property manager or employee could be the subject of a suit. If you have third-party companies that you outsourced to do some repair work to some of these issues that failed, they could end up being involved. But the reason why I mention this is not just to say who can we pass the buck off to, it's as a property management company, not only can you get your own company in trouble, but you can get other entities to whom you report to in trouble. And sometimes that could be the quickest way to lose a contract, is to get your owner sued in a $3.8 million lawsuit.
Yeah, I was going to add, Matt, real quick, not to interject. It's like, it's so important because, yeah, I'm sure you've noticed it in South Carolina in general, our plaintiffs' attorneys usually cast the widest net possible, right? And then they sort it out later. And so that's why that documentation is also important, because it may be meaning you getting in and out of a suit as well. Like, you can show that this has nothing to do with us. And, but I mean, all those are great points. I just wanted to interject there on that, is that just because you're named, it may not mean that you're liable, but you have to have that documentation to show why or why not.
Absolutely. So with that, I think we've exhausted that first case study. Now we'll go to some that are maybe a little bit less physically scaring, but still potentially scary, and what I think a lot of people have experience with. We will call alleged mold, and I should have put mold in quotations because I try not to use that word. Instead, let's use the phrase suspected microbial growth, or SMG for short. So we can go to the background here. Fax pattern here. Resident complains of discoloration in their apartment. Property management dispatches their maintenance to come out. They spray the area with Kills or some type of homemade spray that they buy at Home Depot, close out the work order. Resident continues to complain about the discoloration, the smell. They're in your leasing office every day, yelling, causing a stink, causing you to lose other residents, causing people to not want to sign up, or sending emails, however they can complain. Maintenance comes back out, they repaint the same area, they don't smell anything, they close it off. Resident keeps complaining about wet spots. So now you go ahead and you hire a third-party company to perform sheetrock repair. They cut out the sheetrock, they don't find anything behind the sheetrock, and they think everything's finished. Well, a couple months later, the resident's in your leasing office complaining that they've been sick for the past couple months. Pick your poison. It can be asthma, it could be a cold, it could be headaches, loss of sleep, whatever, what have you. They then hire a lawyer and they file a lawsuit. So that is meant to cover several different areas, may not all be in the same case, but to spark discussion points. So what are our discussion points here? How do you, next slide, please. How do you respond to this? I think SMG is probably one of the most frustrating types of complaints that most property managers get. I don't have any statistics to back that up, but I find that more often than not, that is the most frustrating, because people will oftentimes complain about smells or colors that have absolutely nothing to do with mold. But it's that one time that you think it has something to do with a stove, but it actually is a leaking valve from a refrigerator behind the stove that is the problem. So you have to properly respond to the allegations, very similar to the first part. Take every complaint of SMG serious. Make sure that your maintenance staff is following whatever written policies and procedures are on site. If the policies and procedures are to do 1, 2, 3, 4, and 5, make sure they are doing each one of those steps. I'm not going to say what those steps are, and it could be evaluating, it could be taking moisture readings, it could be painting, it could be taking samples, pictures, whatever it is. Make sure that they are following their protocol and documenting what their response is. I can't tell you how many times I've gotten into litigation, seen a work order that says customer complained of suspected mold, came out and sprayed the area, closed the work order, and that's it. No pictures, no documentation on what was sprayed, nothing, no mention of the time, all of those kinds of things. It is very important to make sure you are documenting the 4 W's. Who came out? What did they see? What were the pictures? Because I can promise you, if we get to litigation, the resident is going to come forth with a picture that probably looks 30 times worse than the picture that you would have taken at that particular moment. And it happens oftentimes because they don't necessarily have the picture from that day, but they have a picture from days later after maybe they spilled cornflakes or something else in that area. So make sure you're documenting those allegations.
And a picture's worth 1,000 words. If you've got pictures, I mean, I know a lot of times some of the things that we faced is that you've got residents that don't want to run their air conditioning. And so they're creating that moist environment that can create the SMG. Well, if you're taking pictures showing that they have their air conditioning off on their thermostat, or their air conditioning turned up to 85, or whatever the case may be, those pictures really help us create the story of what's actually been happening in that particular apartment home.
Absolutely, because these more often than not, Wendy, and I don't mean to cut you off, but
No, it's great.
Your point is well taken. More often than not, these cases of alleged SMG exposure come down to a he said, she said, where, and I'm dealing with this in a case right now where a resident vehemently states, no, I was running my air conditioning properly. How dare you accuse me of not following procedure? And why that's important is because attached to most contracts, there is a mold or mildew addendum that the resident signs and agrees that they are going to abide by the policies, and they understand that their air conditionings have to be run at a certain threshold or it could create problems. And that all impacts these types of claims, liability, damages, causation, and so on and so forth. But let me get down to that next bullet point, which is document preservation, not only internally, but externally. I cannot think of many cases where when a third-party company is hired to come out and cut out sheetrock, or to investigate or to take moisture readings, that
Extract
a
water.
report yeah, exactly, extract water, apply dehumidifiers, name your example. More often than not, the file that I get as the litigator involves an invoice, and that's about it. And that's it. It's an invoice of how much you paid that company. What I don't have, and what is important to me, are what are the photos that third party company took? What was their findings? What was their report? What did they notice? Does their explanation support what the property has said or not? Both the good and bad. Not just, if there's a time where we haven't done something correctly, we need to know that. We need to know if, in that particular instance, so that you can potentially address some of these things before they turn into lawsuits. If you find out that there was something that you were put on notice of, and then the company came out and there was a big pile of mold behind sheetrock that had been festering for months, well, management might have some creative options to potentially offer that resident that could involve a release. Now, I'm not suggesting anything untoward here, but it's a lot easier to address some of these issues to make people happy before they go ahead and file a lawsuit and hire a lawyer. And then some of the same questions: who is liable? And a lot of these times, the same companies that I mentioned in Fact Pattern 1, but this is where I want you to also think of a third-party liability, or what I will also refer to as breaks in the chain of causation. Legally, to bring a suit, and again, every jurisdiction is different, you have to have, in a negligence case, you have to have your duty, duty to maintain an habitable property. Then you have your breach, and then you have damages. What I would say is, if your property maintenance staff has done everything they're supposed to do, and then you go ahead and bring in a third-party company, and that third-party company tells you that everything looked good and they addressed the issue, but maybe they missed something, or maybe they created a problem, made it even worse. Well, now from a defense posture, we have the ability to say, we did what we were supposed to do, and we then brought in an expert. It's now no longer our fault of any exacerbation from that point in time forward. So what that does is it potentially can break the chain of causation. Now, it's a double-edged sword, because as Thomas alluded to a little bit ago, plaintiff lawyers love defendants to be pointing the finger at each other. That's an issue for another day. I bring this up because when you're talking from a property level, the goal here is to, for protection. And the best way to protect is to be following your protocols and then hiring the experts when you need to hire the experts.
Right. And I would add, Matt, to your points, is if the big picture here is that your on-site team is your first line of defense. Like they are taking that information in, and what they put down, it can dictate your trial strategy or your negotiations. I mean, it's very important. Documentation, what you're seeing and perceiving, and these 2 points, these 2 scenarios, that documentation plays a factor in all those decisions.
And so now let's talk practically at the property. If you use a piece of equipment, document it. What did I use? What concentration? Take a picture of it. It's a lot easier to take out your cell phone and screen and take a quick take a quick picture of the spray bottle that you used. If it has the name on it, if it's no label and you mix it up yourself, take a picture of something different. Water is the worst enemy sometimes of a property, because it could be nothing, or it could lead to something much worse. And what you have to understand is what you may think is an innocuous or a small problem in an apartment can be bigger to somebody who might have a compromised immune system, for example. I had a case within the past couple of years of an individual resident who she just, your heart goes out for her, because everything impacted her worse than a traditional person. But as most jurisdictions will say, you take your plaintiff as you find him. You don't get to pick who your plaintiff is. So if that person has a weakened immune system, and just the tiniest little bit of mold, or even the slightest form of household mold causes them to have an asthmatic reaction, that's your plaintiff. You don't get to say, oh, it's really not that bad.
That's right.
So make sure you are treating every allegation as if it could be the worst case scenario. And I know that sounds very bleak and dire, but as a lawyer, if I try to imagine the worst case scenario, I'm more oftentimes doing the best for my client. So as an on-site personnel, if you are trying to imagine every potential claim turning into something bigger and you are documenting it and treating it with that level of respect, you will more likely than not protect your property more so than you would if you haven't been doing that.
Hey, Matt, there's a question in the chat that I just want to bring up.
Fantastic.
We have one of our members asking about disclosing previous mold issues on a property lease. And, I'm not sure about that because I'm not an attorney, but his question is, in disclosing previous mold issues on a property lease, how far back do you recommend disclosing mold issues, the most current or all previous issues? Is there a time frame, et cetera? And I was not aware that we needed to disclose. I don't know if you have any comments about that.
That may be jurisdictional, so right? I mean, that's where we are. Sorry, Matt, I didn't jump in there, but yeah.
No, Thomas, I think you feel free to take it.
I mean, yeah, I think that's very jurisdiction. You'd have to look through your laws, what your disclosure requirements are, right? Because you are a real estate professional. And so there are some required disclosures that you have to meet in each state, I'm sure. I mean, I can give you South Carolina as an example. I mean, if there's the switching gears away from the SMG, is if your apartment's flooding constantly and there's constant water and that the flooding is going to impact, you have a duty to disclose that. Prior SMG, I think for South Carolina, that would be a question if it's directly asked. This is only for South Carolina, obviously, but if you're directly asked that question, then you would probably have some form of a duty to answer that. I don't know if that's a direct requirement. It's all jurisdictional. It's all your jurisdiction specific. So I'm not sure where you were located, but you'd have to look into that if Matt wants. You want to piggyback on that, please?
But what I hear, there's something about that question that I absolutely love from a litigation defense standpoint. And it's, if you have an allegation of, well, I hate to use the mold word, but let's say there's actually mold found in an apartment or SMG, and someone complains about it, and then that resident leaves, and then you re-rent that property, and the next person gets sick. Well, in the course of litigation, one of the questions that you'll get in discovery is all prior instances of SMG. Now, a good defense lawyer will limit those requests because you're not going to want to turn over everything from the entire property, but a lot of judges will give you for that particular unit or the units in and around that area that may have an effect on it. If it's a lower level unit, they might give you the records for the property right above it, because if there's a leak in apartment 308 that might impact 208 or 108, that all might be relevant. So that's a fantastic question, because what it also shows is you can't be so myopic to only focus on a particular rental term. So just because a resident leaves doesn't mean that everything starts brand new. It's the condition of that apartment and what knowledge you had. So if you had knowledge of a problem there and then you go and re-rent it to the next person, you have to make sure that you have properly turned that apartment. You've investigated all the potential issues rather than just painting over a coloration spot.
Well, and that's a great answer. And this is Phil, and he's in California, and he says they have lots of disclosures there, LOL. So I have a feeling that's
sorry to hear that.
So, but thank you for the question very much.
Fantastic. All right, I'm going to go to the last case study so that we can leave at least maybe 10, 15 minutes for Q&A like that. This last one is a little less probably appealing than the first two, but shows equally the dangers of what could appear to be the smallest issue.
But it's been coming up recently, right?
It's been coming.
The last couple of years, we've had incredible ability to have rent increases with the economy that we've had, and our renewals, have really seen tremendous increases. So I think it's extremely relevant in these times right now, Matt. And I'm glad you're going to cover it.
Thank you, Wendy. So before we get into the background facts, I want to get everyone thinking about incident in a broad context. Not every incident, I would suggest, is a slip and fall or a security issue. I would encourage you to document any complaint that you get from a resident and consider that an incident. And here's why. Let's go to the background facts on this one. So resident receives your annual renewal notice and is unsatisfied with the increase in cost. Could be various different reasons. Maybe they lost their job. Maybe they're hit hard by the economy, inflation in their particular area. I'm not trying to get political right here, but one reason or another, they're not happy with how much it's going up. And so they ask for various different hypothetical increases on different terms, whether it's a year or 2 years or month to month or 3 or 4 months. The resident is now coming into the leasing office and they're yelling, screaming, complaining, alleging somehow that they are being treated unfairly. They don't like any of the options that they are given that I just mentioned, but they might pick one particular option. Well, at the next renewal, they're even further unsatisfied with what they believe is an even bigger increase. So the resident goes ahead, maybe they don't file a lawsuit, but what they do is they go ahead and file an agency complaint. North Carolina Human Relations Commission, South Carolina Regulatory Department, Georgia Office of Consumer Affairs, pick your state's real estate governing agency. We've also seen Department of Justice complaints. And what the resident now alleges is they're being mistreated because of their age, sex, race, or creed. Whatever it would be, they're treated differently because they're male or female. They're being treated differently because of their sexual orientation. They're being treated unfairly because they're old or they're young, or they're treated unfairly because they have small kids or because of the color of their skin. Pick whatever potential ethnic group or minority or distinction, and they're complaining about it. And they go ahead and file an agency complaint. Now, maybe your exposure wouldn't be as big as a $4 million judgment if somebody got attacked. But what now has to happen is the company's real estate license is now being scrutinized by an agency. Company has to hire a lawyer to respond to those complaints. Your lawyer might be spending a week and a half in fax gathering. And as some of you may have experience, HUD might need to take witness statements, question C-suite level officers, take time out of Wendy's day, just to pick on her because she's a panelist right here, to ask her about something that she had absolutely nothing to do with, all because a resident didn't like how much their rent was going up. So this might sound cynical, it might sound short-sighted, but like we said, we're seeing it over and over and over again, where people will attribute what they think are discriminatory practices to them individually because they don't like what is happening. So from a property level standpoint, how do you deal with this? Because I know what most of you are saying on this call, hopefully all of you are saying on this call, which is, I would never in my right mind think to treat someone differently because of who they are. Well, now let's go to the discussion points. Document communications, okay? So not just when somebody files a complaint or a work order, if they're upset about their rent increase, if they've sent you an email, save the email. If they're coming into your office kicking and screaming, ask them to submit a request in writing so that you can address it. And if they don't want to do that, document it on your end. Write some type of memo to the file, something that you can document that Mr. and Mrs. Smith came into the office on September 28th at 2:43 p.m. Eastern time, and we're complaining about this. Uniform treatment of residents. A lot of properties, not every property, will use LRO pricing, or they'll use different comps, and they'll find computerized data to go ahead and figure out what those rental increases are going to be. Most people are not just coming up with that number out of the blue. There's a lot of factors that go into figuring out what those numbers are going to be. But if 6 months down the road, you have a lawyer coming to you to say, all right, what went into that? And you don't have the documentation to back up your exact thought process. Well, now you're having to explain, and it's your word against their word. Whereas if you have the documentation to say, here are the comps that we ran, here were the specific numbers on this date that we pulled for all residents on that particular property. These were the types of units that we compared to at this property, and this property. You have now done yourself a service in providing the protection if someone were to attack your credibility. And that's what I just mentioned about preservation of comparison data. And I took these in reverse because the uniform treatment of residents, everybody wants to try to go help each resident. We get it. You're in the customer service industry. You want happy residents. Happy residents renew each year and they stay on, and those boost your occupancy rate. However, if you go ahead and give Mr. Jones one offer and then Miss Smith a different offer, or they've been with you for so long and you want to cut them a little bit of slack. Well, when that investigator starts asking, and you now have to describe some disparate treatment that you gave to a couple of different people, and let's just so happen to say that one of them happens to have one color skin and another happens to have another, all of a sudden you have created the appearance of impropriety. You may have had absolutely no subjective or objective intention for it, and I'm just using discrimination as an example here, but now to a third party neutral, they see one person treated one way, another person treated another, and they investigate it further. So the best way to help provide protection is for documentation and treating everybody equally. Because the second you start picking and choosing who your favorites are, somebody's going to get their feelings hurt and they're going to accuse that they got disparate treatment.
It's so important, and especially in these times right now. And also, I know that for us, and some examples I have out in the field are that you have folks that are coming back and they're wanting to stay, but they can't afford the increase. And then you may have some negotiations going on. We have to be very careful with that. You can't just negotiate and give one person one rate and one person another. You've got to make sure that you're uniform across all of those rent increases. It's very important because you can get yourself in hot water.
And while you may not get sued in court, you may get sued in court. That may not be the first step. Somebody might go to an agency and then they might take that a step further if they think there has been some level of retaliation or discrimination. It could be somebody thinks that they didn't get renewed because they've been submitting 100 work orders in a month, and they felt that because they were protecting themselves, they are now being treated differently. So you can take this fact pattern and imagine all sorts of different permutations. But the point is, you can, like Wendy said, you could get yourself in hot water. You could get your C-suite individuals or the license holders in hot water and get them targeted by these agencies when that's the last thing that they want. And if you lose your license, well, now you've potentially lost that property.
Exactly right. So
we got about 13 minutes left. I'm happy if there's any Q&A and people that have any questions.
There was a couple of things in the chat that went back to the SMG example, and the suspected microbial growth is the term that we use at Pegasus Residential. It's just for us, it's the way that we want to describe that, and it worked well for us. So anybody on the call, that's what we call it. So we have one person that asked, if you have known mold, you shouldn't you have the all clear test by an outside agency?
I mean, I think that's a great question. And that, I'm actually going to answer that question and another question that we got, which is realistically, every day I have complaints of some sort. Are we to file an actual incident report for everyone or simply record and document in memos per se? I'm going to address both of these together because I think they highlight what some people will say in a theoretical world, which is what some people would accuse Thomas and I of preaching, and then the real world, which is, come on, Matt and Tom, practically I can't do this every day. I have thousands of residents in my property. And the best way to answer those questions are, yes, in a perfect world, you do all of these things. At some point, we do recognize that we don't necessarily live in a perfect world. So then it becomes a question of risk tolerance. And this is a question from a company level of, if you can't do 100%, what can you do to help provide the best protection for the company as possible? So yes, maybe you don't want to spend 3 hours out of your day doing an incident report for every single time somebody complains about something. But if you can do, like one person suggested, memos to the file or shorthand or some type of log to at least provide some level of documentation. If somebody comes in and complains, if you have just a written log that you keep and then you scan it at the end of the day, or you keep it in a log book. As far as the all clear, obviously that would be great evidence to have in a defense case if somebody alleges that. We do understand that practically every time somebody complains of a little spot, you're not going to go hire an outside agency to go test everything, because your owner is going to be very upset with how much money you're spending on remediation. So that's where we say each company's policies and protocols just need to be followed and are important. If the policy and protocol is to take it in a couple different steps before you go to a third-party company, make sure you're just following those protocols. If the situation requires you to go or necessitates it, then that's a little bit different.
Another question was asked, should we share the air quality or mold testing results with residents?
Thomas, do you want to take this one or you want me to? I've talked
The answer to that. I mean, no, either way is fine. And you can piggyback on this because my response to that is it depends. And I know that's not the best answer, but it depends on the situation, where you are. When you got that done, did you get it done in anticipation of litigation, or were you doing that as a defense of, here's it all clear? What we usually generally suggest is if the resident got an air quality test and then you got one subsequently at the same time frame, what that's used for is to determine whether you want to push back, how hard you want to push back, and what the actual conditions are, because then it gives you a snapshot of what that is. And do you have a defense? Are we going to fight this and potentially lose millions of dollars or hundreds of thousands of dollars, or can we settle for 5,000 or 6,000? And so, if it's anticipation of litigation, we want to be as willing to share it. It may not be discoverable. It could be you're going to file some motions maybe to quash, depending on what's going on there. But that's going to dictate how you settle. And if it's favorable to you, we probably wouldn't share it. Just to say, here, no, you're making this up. This is not here. It's not clear. You can just get it just as thick outside as you could inside. So it's very case by case basis, fact specific.
Next question was, with fair housing, is it true you can be personally sued for negligence and discrimination? Do you guys want to take that one?
Thomas, you want to take that one, or you want me to?
Sure. Oh, I mean, yeah, absolutely. Any cases, I know in South Carolina, it names everybody from the individual all the way up to the ownership group. I mean, it's a shotgun filing basically, right? That we don't know all the names, we don't know all the people, but we're going to throw them in there, see who's responsible, and then figure it out. So if you're a licensee in the state of South Carolina, you can be as well. And the individuals, if you work on site, you probably can as well. Usually the ones that I see in South Carolina, they name anybody from the assistant manager to the property manager. I've had people add maintenance because of comments that were allegedly made or said. And then your organizations also get added in too. And then you go through that process of trying to just filter that out through your defenses and your documentation. And that's where the documentation comes in. Well, I had nothing to do with this, so I should be removed.
And I would add to that, if you think of it from the sense of one can be responsible for their own action, a manager can also be responsible if they know of an action and fail to take action to prevent about it, or they had the power to correct it. So there are several different ways that people could be liable. And I'm just picking for discriminatory housing practices under the FHA.
Yeah. And one of the last questions is what is the correct way to treat mold related issues in a unit? And of course, this is not, this webinar is not all about SMG. I think there have been other webinars that NEA has done that talks about best practices. And I'm pretty sure that they have a kit on that, but I think that James could answer that at the end of the questions. I know that at Pegasus, we have a protocol, policies and procedures on how to take care of SMG and what's expected of our team members when they come across suspected microbial growth, and we follow those protocols to the letter of the law. So,
yep.
I don't think that I could really.
Wendy, you just said something that.
Mm-hmm.
Sure, Wendy, let me just jump in real quick because you said something that triggered a thought that I had earlier and that I left out from my planned remarks. When you are documenting under those 4 W's, it is very important that you think about the wording that you use. If in your document you wrote, found mold, treated it, something to that effect. Well, now you have just admitted the presence of mold.
That's right.
You be very careful with the way that you describe things in your incident reports or on your documentation, because from a defense posture, more often than not, the position is it wasn't mold, it was some suspected growth, but it wasn't any of the known molds. Well, if you go ahead and I get a document and my client gets cross-examination, say, one of your defenses in this case is that there was no mold there, that there was suspected microbial growth. And we say, that's right, it wasn't found to be mold. And said, well, here's a document where you all said mold and treated the mold. How are you now changing it to be called SMG now that you've been sued? And that's pretty damning in front of a jury to use somebody's own words against them. So I use that very rough example to get you thinking of how to make sure not only when you take the time to fill out the reports that you are thinking about the words you are using. And we're just picking on mold right now, but it could run the gamut of any of the issues in an incident report.
Yeah, and that
Any
goes
of
for
these
anything you put in
cases.
writing.
Yeah,
Anything in these
anything-
cases, text messages, emails, you have to be careful, especially if you're talking about the party too. Everything's discoverable. You just have to be careful with your wording.
Just remember, words matter, and whatever you put in writing, most likely it's going to last for a very, very long time. So choose your words very, very carefully. And I always say when doing the incident reports, stick to the facts. Don't add emotions. Don't add things that aren't there into those paragraphs. Like, really just think about what you're writing and how it's going to look. And would you be okay in representing what you've written in a court of law or in a newspaper article or to your, ownership group? So it's got to be written very well, but also very honestly and very factual. So, the whole goal of this is to give everyone on here some food for thought in how they're filling out their incident reports with those 4 W's, and how we can be honest as an industry and also protecting ourselves and our ownership groups by having excellent documentation. There have been some fantastic questions in the chat. So I don't see any other questions in the chat. Did you have any closing remarks that you wanted to mention, Matt, before I turn it over to James?
No, I mean, again, I know there's some other questions that are starting to come in, and it's very tough and I don't want anyone to think we're being dismissive. The point of this webinar was, again, to get everybody start thinking about incidents in a different way to help protect the companies from liability. There are other webinars put on by the agency to talk about those best practices. Our focus between Thomas and myself and Wendy was to get everybody thinking about how those best practices fit in with exposure, liability, and risk to the company. And once people start thinking in those terms, it helps the companies tremendously in avoiding, or at least not avoiding, in minimizing potential exposure and litigation, because sometimes you can't avoid it altogether in this line of work, unfortunately. But I want to thank everybody for taking the time to listen to me speak for probably longer than most people would sit and listen to me. I really, truly appreciate it. Thomas and Wendy and I have worked together for years, so I appreciate them as well. Thank you.
I appreciate so much both Matthew and Thomas. Your insights were just incredibly helpful. For any follow-up, our email addresses are displayed on the screen here. You're welcome to reach out to any one of us, and we'll be happy to correspond with you. Obviously, Thomas and Matthew are lawyers, and they're willing to help you, but they are paid attorneys, so don't forget that. I also want to just mention, if we didn't get a chance to answer any questions in the chat, I'll try to get them answered for you. And I'm going to turn it back over to James Campbell, who's with NAA, and he's always the greatest at rounding us up and keeping us on time. So thanks to everyone who joined us today.
My pleasure. Thank you, Wendy. Thank you, Thomas. Thank you, Matt. Really outstanding webinar, and we're grateful for your insights. For additional resources, NAA maintains an online portal for its many offerings in industry operations and compliance for the rental housing industry. The URL is featured below. And Wendy, I do recall that we have materials on mold. I know we have a webinar.
Fantastic.
We have a mold action kit, and I believe our legal team has posted some information there. So you're always welcome to go to our website and see what's there. Another question that was asked was, will this recording be available? Yes, we will post this recording to NAA's YouTube channel, most likely posted early next week. I know someone in the Q&A had said that their managers are meeting tomorrow at 10 o'clock in the morning, and they would love to have the managers view this. Unfortunately, it won't be up that soon, but you can always forward them the URL, and they can view it at their leisure when it's posted next week. So with that, again, I want to thank all three presenters, Wendy, Thomas, and Matt. This was really terrific. I want to thank our audience as well for your participation. We value your membership and we appreciate your attendance. We wish you all to have a great afternoon.
Thank you all so much.
Thank y'all very much. Take care.